I call to order the Ways and Means hearing for Wednesday, April 16th. Mr. Smith will note the roll. Representative Davids moves approval of the minutes from April 2nd and April 5th. Are there any additions or corrections? Seeing none, all those in favor say aye.
Aye.
Opposed, nay. Minutes are approved as distributed. We're going to first take up the Swedzinski bill, House File 2786. Representative Davids moves approval of House File 2786. Welcome to the committee. If you'd like to explain your bill.
Thank you, Madam Chair. House File 2786 is a pretty straightforward bill. We've had a few cities throughout the state, I believe about 18, that failed to get their paperwork in, file the necessary requirements to the state in order to receive their LGA payments. A number of them have completed their paperwork, to my understanding, but there are a number that have not. This bill simply extends the deadline to May 31st of this year for those cities to complete their paperwork to receive their 2011 local government aid payment. That is pretty much it. A few of the cities that have had routine failures to get their paperwork in have changed. A few have contracted with other cities. Just something to keep in mind, committee, Madam Chair, is simply that a lot of these cities are small. Some of the folks that are in elected positions in these cities sometimes don't know that they have been elected until the morning after the election. And so sometimes getting the paperwork done and figuring out how the operation works is a tough process, and I appreciate committee support. So thank you.
And there's an A3 amendment in the packet. I believe it makes technical changes, and there's a transposition of numbers that also has to be corrected. Representative Davids?
So moved, Madam Chair.
Any questions on the A3 amendments? Seeing none, all those in favor say aye.
Aye.
Opposed, nay. The A3 amendment is adopted. Any questions on the bill as amended? Representative Luncheski.
Well, thank you, Madam Chair. I don't really have a question for the author. I just encourage folks bipartisanly here to oppose this bill. Members, this is a forgiveness note for a bunch of cities who aren't doing what they're supposed to be. They are supposed to report, and for many of us around the table, our constituents pay higher taxes so that other communities can get local government aid. And we would ask that they at least have to report in a timely fashion. Madam Chair, this, as you know, local government aid, you're the Ways and Means Chair, you know that the taxpayers across the state spend $500 million a year to give money to these communities, and they can't even get their reports in. Now, I understand this is a broad forgiveness bipartisanly, but it's actually quite ridiculous. We now have the situation where 40% of our cities are not meeting their requirements to the state auditor in a timely fashion. Now, this is only 28. We have 854 cities. I think it's 28 or 24. I'm not sure what it is. But allowing this forgiveness to go on says, we don't really mean it when we raise taxes on people and then do wealth redistribution in the state, and you don't have to report. And, if times are tough, it's just okay. It isn't okay. This bill, I'm sure is probably just a tax vehicle for other purposes. If it was legitimate, it belonged in the omnibus tax bill. But members, if you look through the list, and it is bipartisan, there I'm sure are some hard luck stories here, but this is just a broad forgiveness. And we have a state law. This is not a local decision. This is a state significant tax program. We spend about $1 billion a year in tax aid to communities, whether it's fiscal disparities, local government aid, county program aid, and this is a big one. I mean, $500 million a year. And so we ask that when we give these gifts to these cities that, quite frankly, a lot of our constituents get tired of giving, we ask that you get your report in. That's it. It's not too tough. So, the state auditor has to review that these cities are meeting the requirements, and this is sort of, it's not a no strings attached program. And in fact, I have watched the current majority say we ought to limit local government aid just to police or just to public works, or cities of the first class shouldn't get it because they have a sales tax, or, we generally hear this sort of rhetoric of tightening the LGA and proving that you won't buy a water fountain or whatever. And now what this bill does is said we're going to say, actually, we don't mean any of that, and you don't have to report. So members, you all, every one of your constituents, whether you're a recipient of this program or not, and about half of Minnesotans, just for the public, Madam Chair, half of Minnesotans live in a community that does not receive local government aid. Now, it's a small set of cities, but those cities have a lot of people who live in them, and a bunch of us here bipartisanly represent those people. So half of the Minnesotans in this state do not receive local government aid. Half. Yet they pay for it. And the other half receive it, and they pay for it too. We all pay for it, but only half of Minnesotans are beneficiaries. And just like Job Z or any other tax credit program, like an angel investor credit, we make people come in and do their accounting. So I hope members will, my guess is it's going to pass because it's here, but I want for the record, Madam Chair, and I appreciate you allowing the comments, that this is a forgiveness of failing to report, and it is, Minnesotans pay higher income and sales taxes to pay for this program, and I'd urge people to vote no.
Jimmy, what do you got?
Representative Carlson.
I have a question, Madam Chair, of the author. Does Department of Revenue give out any kind of a reminder notice to these, or to cities generally, that their paperwork is due?
Representative Swedzinski.
Madam Chair, Representative Carlson, yes, I believe they've got a series of notes and letters that they send to the mayor, to the city clerk, and also to the representatives that represent the cities within the legislature. I don't have an exact line of when those dates are. Actually, I probably have a little bit here, but yeah, they usually give a month notice every 30 days up until September, and then they're getting final notice that they obviously will not be receiving when they don't get their check. But kind of also in response to that question, but also to Representative Lunchewski's point, you know, some of the city, my city of Vesta, happened to go through a national disaster. They did happen to have a tornado that came through town. So, you know, that's really where this bill came from. I don't believe it's a vehicle bill. I've carried other vehicle bills in the past, mostly deal with cars, but I think this bill is pretty straightforward. Rather than select the cities in which we're going to be receiving and not, I decided to let's put all the cities together that have not received their paperwork. This isn't a forgiveness. This is a simple extension of timeline to get their work done, and I think the state does need to, and it's in a duty to require that the cities have their paperwork done. We felt because of the extenuating circumstances of some cities, and rather than picking and choosing winners and losers, we decided to put the cities together in this bill, and I'd appreciate your green vote. So,
Any other questions or comments?
Madam Chair,
Carlson.
yeah, he went beyond my question, but you know, I think it's important to note then that they were given notice that the paperwork was due, and the author indicates that notice was given several times, apparently. We're all facing a deadline tomorrow. I mailed my taxes in today. We're aware that we all have certain deadlines that we have to meet, and they apparently, for whatever reason, chose not to meet the deadlines even when they were given reminder notices. Thank you.
Representative Biscombe.
Thank you, Madam Chair. I'll also note that of the 18 cities listed on the House Research Bill Summary, 9 of them were given filing extensions and still missed, given the fact that they were even given extensions. So I would have to agree with my colleague from Bloomington.
All right. Seeing no other comments, Representative David renews his motion that House File 2786 as amended be recommended pass and referred to the General Register. All those in favor say aye.
Aye.
Opposed, nay.
No.
Motion prevails. The next bill in front of us will be House File 1476. Representative Scott. And members, first we need a motion to remove this bill from the table. So I will make that motion. All those in favor?
Madam Chair, I'd like a roll call.
All right, and Representative Carlson has asked for a roll call on the motion to move House File 1476 from the table. Any questions on that? Seeing none, Mr. Smith will note the roll. Take the vote.
Representative Holberg.
Yes.
Representative Downey. Yes. Representative Carlson.
No.
Representative Abler.
Yes.
Representative Bruce Anderson.
Yes.
Representative Sarah Anderson.
Yes.
Representative Beard.
Aye.
Representative Breinert.
No.
Representative Biskins.
Yes.
Representative Champion.
No.
Representative Davids.
Yes.
Representative Eakin.
No.
Representative Garofalo.
Yes.
Representative Gottwald.
Yes.
Representative Greiling.
No.
Representative Gunther.
Yes.
Representative Hackbart.
Aye.
Representative Hamilton.
Yes.
Representative Hornstein.
No.
Representative House.
No.
Representative Huntley. Representative Kahn.
No.
Representative Kiffmeyer.
Aye.
Representative Lanning.
Yes.
Representative Lencheski.
No.
Representative McNamara.
Yes.
Representative Nornis.
Yes.
Representative Pulowski.
No.
Representative Rukavina. Representative Slawick.
No.
Representative Smith.
No.
Representative Wagenius.
No.
Representative Westrom.
By a vote of 17 ayes and 13 nays, the motion to remove House File 1476 from the table prevails. I will then move House File 1476 for consideration by the committee. When we left off with this bill, we have a committee engrossment in the file that reflects the amendments that were placed on the bill in the committee. We also have copies of the original bill and the amendments that were adopted in the previous committee hearing. In addition, there's two additional amendments for today, the A7 and the A8 amendment. In addition to that, there is an updated fiscal note in the packet as well. Representative Scott, welcome back to the committee. And we have an A7 amendment which will place the appropriation of $192,000 from the general fund to reflect the total cost of the fiscal note. Are there any questions on the A7 amendment?
Move it.
Seeing none, all those in favor of the A7 amendment say aye. Aye. Opposed, nay. The A7 amendment is adopted. We now have the A8 amendment in front of us, and if you'd like to speak to the A8 amendment, that actually amends the A4 amendment from the previous agenda related to a study, and given the $80,000 cost that was attributed to that study in the fiscal note, the A8 amendment would remove the study and the $80,000 from the bill that we just amended. And I would move the A8 amendment, and if you'd like to speak to that.
Thank you, Madam Chair. I just wanted to say, it's fine to remove it and all that. I think it should be the purview of each agency to keep track of numbers like this. I think it's only fair to the taxpayers, but in the interest of moving this bill along and saving the $80,000, go ahead and vote.
Members, any questions on the A8 amendment? Seeing none, all those in favor say aye. Aye. Opposed, nay. The A8 amendment is adopted. I think we now have the bill in the shape in which the author would like to consider it. Are there any additional questions? Representative Abler.
Thank you, Madam Chair, and members, and the audience. I voted yes today. I don't believe in this bill. I don't think it's going to become law the way it is. I think it's a problem. I commend Representative Scott and McNamara for their work on this. There are some people here today and listening who are terrified about the prospect of their jobs and what this might mean. I think there are some things that could be worked out in an amiable way that still could go forward in this bill, which is why I'm voting to move it out today. I do know in the current form it will not become law. So I urge the people who are working on this, who are trying to, in the name of labor, trying to give the labor individuals some more flexibility in their scheduling, especially outstate, where they can only have to work 4 days to get their 40 hours in, if that makes sense, and save some $4 gas. That part appeals to me. Other parts of it, I think, are quite a ways off, and especially given the tense environment. So I hope that the people on both sides of the aisle recognize my sincerity in trying to find a path to here to get a bill signed that can actually relieve some of the burden on the working man who's had this the most challenging bit of time in the last couple of years, and the contractors who are trying to stay open to hire the working man. And so that's why I'm voting yes, and I urge members to support the bill today.
All right, thank you. Members, it's been brought to my attention that we do need to amend the A7 amendment that was adopted at this point so that the numbers work. And so on the A7 amendment, line 5, delete 192,000 and insert 112,000. Any questions on that? Seeing none, all those in favor say aye. Aye. Opposed, nay. The oral amendment is adopted. Any additional questions? Representative Carlson.
Madam Chair, just as a reminder, we know that this bill has very strong opposition from representatives of the labor movement. Actually, many years ago, I chaired a special subcommittee that dealt with this issue, and I might have commented about that the other day. And a similar proposal was voted down by a very strong bipartisan vote at the time in opposition to repealing the prevailing wage. And we actually had presentations at that time from both labor and contractors that were lined up with labor, if you will, in opposition to removing the prevailing wage provisions from law. And so this morning, with that history in mind, I would encourage, Madam Chair, a no vote on this bill and also, again, request a roll call vote.
Thank you, Representative Carlson. A roll call vote has been requested. Representative Gavel.
Madam Chair and members, just for the record, we are not repealing prevailing wage in this bill. We are reforming it. This is the way that most other states do it. And I get tired of that characterization, Representative Carlson, that we're repealing prevailing wage. We are not in this bill, and I just want to make sure that we're clear about that.
Representative Carlson.
No, Madam Chair, it greatly changes current law, and you can characterize it as not repealing, or I can characterize it as repealing, but at any rate, it greatly amends current law, and that's why I'm opposed.
Thank you. Any additional comments? Representative Reinhardt.
Thank you, Madam Chair. I just wanted to inquire of Representative Gottwald about his comment that this is the way that most other states do it. That is not my understanding, so I'd like a little clarification on exactly what elements of the law he thinks are parallel to other state laws.
Representative Gavel.
Well, Madam Chair, Representative Reinhardt, and I'll ask the author to confirm this. Minnesota is one of the few states that determines prevailing wage under the current method. We are talking here about moving to the method by which virtually every other state that does prevailing wage calculates this. This has been a problem. We've seen news reports about how prevailing wage is currently being calculated, the cost that's added to projects without adding a single additional job in the state of Minnesota. But perhaps, Representative Scott, if you could perhaps comment on how many states do it the way we do it now and how many do it the way we're proposing to do it.
Representative Scott.
Thank you, Ms. Chair, Madam Chair. Yeah, we're one of only 3 states that currently do the pure modal figuring for prevailing wage. We're California, Hawaii, and Minnesota.
Representative Reinhardt.
Thank you, Madam Chair. Representative Scott, what about the other half of that, and that is what state, how many states do it according to the method proposed in this bill?
Representative Scott.
I'm not sure if I have that data with me. I had it when it was heard last time, but I think it's, I don't want to quote because I might be off base, but I know that we're one of only 3 states that do pure modal.
Representative Reinhardt.
Thank you, Madam Chair. Well, I'm not wanting to debate with you about that here, but my point is I think that we're moving in a direction that isn't common to most states in the United States in terms of a methodology, and I think that ought to be clarified in this discussion. I don't think that we're aligning ourselves with most other states. I think there's 2 or 3 other methodologies in between what we currently do and what we're proposing that we haven't explored or discussed.
Thank you. Any other questions before we take the roll call vote? I'm sorry, Representative Rukavina. I heard you had a foot of snow up there this morning.
It was over my head, Madam Chair. And just the reason I want to speak this morning, because, there's a few construction workers in the room I see back there, and, this may be one of only 3 states, Representative Scott, but we're probably one of only 3 states that's trying to take money out of people's pockets, working people. You haven't done it enough this session, I take. Now you got to do more here. When it's snowing up north and Menards is being put up, and I don't like that fact that Menards is going up in my district, but, that's life. That's the way it goes. Big chain stores come in, put the little Main Street people out of business, but the construction workers are working there, and they're working at prevailing wage. But today they can't work. It seems to be a fact that people can't grasp around here. These people work a full-time job, but they don't work a full-time job and a 40-hour week because they can't. It's the nature of this business. It's the nature of our state. As I drove down today, it left my driveway with about 8 inches of snow, which was still up to my knees, I might add, But I just cannot believe that, we are doing this to working men and women and to the middle class, and we just keep hammering and hammering. Our methodology hasn't cost the businesses in the state anymore. It certainly hasn't cost the government. When you use, in my area at least, union wages, union labor, you get oftentimes the best job around, most times the best job around, and the government and the businesses save money in the end. And why you would want to change what's been law for years and years and years and go after the middle class and just keep doing it and doing it and doing it is beyond me. So I don't care if we're one of only 1 state in the nation. It's the right way to do it. But I can guarantee you the other states that have prevailing wages, I hope, after the foolishness we've seen going on in this country for the last year and a half or so, that other states aren't attempting to take more and more away from their particularly union people, but in this case prevailing wage being paid, because the other states are learning a lesson, and I'm hoping that that lesson will be learned here in November. So do what you want, but to say that we're one of only 3 states, we're one of only 3 states taking money out of people's pockets, hard-working people who work in the conditions that I just described, and to pick their pockets is beyond me.
Representative Carlson.
Yeah, Madam Chair, just a quick and maybe final comment, but Mr. Melander testified before the committee the other day that this repeal of the way it's currently calculated or amending the way it's currently calculated without getting into a debate on that issue. Representative Scott, do you have any idea what kind of a pay cut you would be causing as a result of this amendment to the current law?
Representative Scott.
Do you have any idea what you're doing?
Thank you, Madam Chair. Yes, I do, Representative Carlson. And, we're in tight fiscal restraints in this state, and we're trying to make some reforms that are gradual and moderate. These are not overwhelming reforms that we're talking about. They're very moderate.
Madam Chair, that wasn't the question I was asking. You can describe it in any way you would like, but I was asking you what kind of a pay cut you would be imposing on construction workers in the state of Minnesota.
Representative Scott.
Thank you, Madam Chair. Representative Carlson, this bill is an effort to reform prevailing wage, possibly making our state more attractive to other businesses to come in and do work here, and could possibly save our state around $50 million a year in construction costs. That's a lot more roads and bridge projects that would put more people back to work.
Well, Madam Chair, obviously she's trying to share with us her philosophy, but she is not providing an answer to the question. I would think if you were carrying a major bill like this, you'd want to know what kind of a cut you were imposing on the workers in the state of Minnesota that are in the construction trades. Thank you.
Representative Anderson.
Thank you, Madam Chair, and I'll just be brief. I noticed on here that they talk a little bit about the local impact, but doesn't this impact our school districts too? Because are they required to pay prevailing wage right now? Would they see a cost savings under something like this in the 80 counties that are impacted by it?
Representative Scott.
Thank you, Madam Chair. Yes, they would.
All right. Seeing no further Representative Reinhardt.
Thank you, Madam Chair. Just quickly for the record, I did find the reference I was looking for earlier and couldn't get to quickly enough, but our own legislative auditor in the 2007 report does indicate that only 2 other states in the country actually use a mean to calculate prevailing wages. So the other options in between, which are some variations on the mode or using a wage agreed to in collective bargaining, are other ways other states approach prevailing wage. And my only issue there is to say we're not conforming with the majority of states in the country in this bill.
Thank you, Madam Chair. One of the things to remember in this matter is that that was done in 2007. I'm not sure if there have been any other states that have moved and made any of those changes. But again, this is, as Representative Abler alluded to, this is a work in progress, and we are certainly open to negotiating and talking more about this issue as it moves forward.
All right. Mr. Smith will note the roll.
Representative Holberg.
Yes.
Representative Downey.
Yes.
Representative Carlson.
No.
Representative Abler.
Yes.
Representative Bruce Anderson.
Yes.
Representative Sarah Anderson.
Yes.
Representative Beard.
Aye.
Representative Breinert.
No.
Representative Biskins.
Yes.
Representative Champion.
No.
Representative Davids.
Yes.
Representative Eakin.
No.
Representative Garofalo. Representative Gottwalt.
Yes.
Representative Greiling.
No.
Representative Gunther.
Yes.
Representative Hackbarth.
Aye.
Representative Hamilton.
Yes.
Representative Hornstein.
No.
Representative Howes.
No.
Representative Huntley. Representative Kahn.
No.
Representative Kiffmeyer.
Aye.
Representative Lanning.
Yes.
Representative Lencheski.
No.
Representative McNamara.
Yes.
Representative Nornis.
Yes.
Representative Pulowski.
No.
Representative Rukavina.
No.
Representative Slawick.
No.
Representative Smith.
No.
Representative Wagenius.
No.
Representative Westrom.
With a vote of 17 ayes and 14 nays, the motion prevails. The bill is approved and moved to the General Register. Thank you, Representative Scott. The next bill on the agenda is House File 322. I would move House File 322 for consideration by the committee. Representative Scott.
Thank you, Madam Chair. House File 322 establishes a rebuttable presumption of joint physical custody and equal shared parenting for 2 fit parents. We have put in many exceptions and protections and have allowed for geographical distance in this bill. And this bill has had 6 hearings in the House. Currently, we have a disagreement with the courts on what the fiscal cost of implementation would be. You should have some handouts there as to what other states have done, what it has or has not cost other states that have either a bill similar to this that's moving or already has a bill similar to this that is actually law. And I'm here to ask for the committee's support.
All right, and there is an A9 amendment, which will change the effective date. Members, as you can see with the fiscal note, there is current biennial impact. The adoption of the A9 amendment would push the impact into the next biennium, which, of course, is an issue with that biennium. So at this point, I'd move the A9 amendment. Are there any questions? Seeing none, all those in favor say aye. Aye. Opposed, nay. The A9 amendment is adopted. Members, the bill is in the shape in which the author would like to discuss it. Are there any questions? Representative Wagenius.
Thank you, Madam Chair. And I look at the fiscal note, and it says no on local impact. And I am wondering if we are changing the legal standard here, and I haven't been on the Judiciary Committee, so I don't know where we're going, but so once we change the legal standard, aren't all custody agreements open for rechange? And doesn't that have an enormous impact on the court costs?
Representative Scott.
Thank you, Madam Chair. Representative Wagenius. One of the handouts that I have there for you is a fiscal impact study from Australia. They have had a joint fiscal custody bill and law in place for a number of years. And if you look at that handout, you'll see that there's been very little cost to their courts. In fact, excuse me, in some cases, the number of people coming in to file for what we might call a post-decree motion has actually gone down. And there have been, Oklahoma has a law like this in place, and there hasn't been any fiscal impact there. And the number of cases, you'll see the filings of the number of cases as well in Australia it went up a few cases, but not anything astronomical since implementation.
Representative Wagenius.
I don't think you can, since family law is very localized, comparing with Australia does nothing, and even comparing with another state doesn't do much. What we're doing is changing Minnesota's system, and once you say for some parents you can change the presumptions, then it seems to me that you are opening the door, it has to be, opening the door for all sorts of folks to go back into court. And that is the question about this local, there's no impact. I find that astounding, and I also find it astounding that there's so little in the state.
Representative Scott.
Thank you, Madam Chair. Representative Wagenius. The post-decree filing is not, no one can come in and come back in for a post-decree filing until a year after this bill has been implemented. So that gives the court some time to come up to speed with how to handle these cases. But secondly, Representative Wagenius, just because there's going to be a fiscal impact, I don't know if you've gotten any letters from any non-custodial parents and children that have been without the input of one of their parents in their lives. I think this is a small amount of money to invest in making families, in making children have as close to equal access to both parents as possible. And you will find, I think, that there'll be savings in other areas to the state because these children children come from single-parent homes, have a higher rate of teen suicide, drug abuse, teen pregnancy, a whole plethora of social problems that our state and county levels are currently paying for. I think there'll be cost savings established through this move.
Representative Wagenius.
Well, thank you, Madam Chair. I don't think you can say that this will go into effect for a year after, for new cases, old cases can't go into effect for a year. That's a denial of equal protection. So that doesn't seem right to me. Somebody's going to challenge that. But the more important thing is the assumption that this experiment will save folks money. We have no idea whether that is the case or not. And I don't, for one, believe it at all. So to assume that you can use the model of single parent raising a child and then say those kids have additional problems and then moving it over and saying this will solve that problem,
there's no relationship. So I am very troubled by changing the standard we have in the state, which is the best interests of the child, to essentially moving to a parent standard, which is the best interests of the parent. And so it's troubling to me, and Madam Chair, I think it's extraordinarily, we're taking a huge, expensive road that is probably not, is not good for children either. So if I was persuaded that it was good for children, then we might want to take on that expense. But there's no way to persuade that changing the standard is good for children, so then why would we take on this enormous expense?
Representative Champion.
Thank you, Madam Chair. So I have a couple questions for Representative Scott. Representative Scott, I noticed on 8.8 of your bill that it talks about, let's see, 8.8, that the judiciary in contested court proceedings shall demonstrate consistent application of the rebuttable presumption. Can you tell me, based on your information, how many cases thus far are usually filed, and how many cases do you anticipate will be contested as a result of this new legislation if it goes forward?
Representative Scott.
Thank you, Madam Chair. That is in the fiscal note. The fiscal note, they give an estimate there of how many cases they think will be coming forward out of that. Let me find it.
Madam Chair?
Representative Champion.
I know, Representative Scott, that it's articulated or outlined in the fiscal note, but I'm sure that you have some thought whether that information is correct, wrong, or if you're challenged by it, because I heard you earlier say that you are at a loss as to how the courts are determining that there's going to be an increased cost to it. So I'm a little surprised with your response. So could you be so kind as to answer my question?
Representative Scott.
Thank you, Madam Chair. Well, there are some hard numbers in this report, and there are some soft numbers in this report. The hard numbers are, they know how many cases right now and in the past few years have been filed. What we maintain with this bill is this bill, because people will go in on even footing, both parents will go into this action on an equal footing. We maintain that the number of contested cases will go down. It will reduce conflict because, again, both parents know going in that they're on equal footing.
Madam Chair?
Representative Champion.
Representative Scott, maybe I should ask this so that I'm very clear about the bill. I've heard it a couple of times. So when we think in terms of this bill, does this bill also pertain or impact unmarried parents? So let's say, for example, if I'm not married to, I see my good friend Shantara Hardy there, let's say that we had a child out of wedlock.
She's really embarrassed.
I thought I would use that opportunity just to embarrass her, Madam. But let's say two parents have a child out of wedlock, but then there's an issue around custody. So would two unmarried individuals who are the biological parents of a child, would this bill impact them?
Yes.
Representative Scott.
Oh, sorry, Madam Chair. Yes, it would. Under equal protection under the law, it's been proven in the Supreme Court that you have to treat married and unmarried individuals the same.
Madam Chair, follow up.
Representative Champion.
So with that, is it not true that based on two unmarried individuals, that there's an extra step or two that has to be determined before we even get to the issue of custody? Isn't that right?
Representative Scott.
I believe there are, but those are already, nothing in those laws will change.
Representative Champion.
Thank you. So I understand that that's not going to change, but I'm getting more to what this committee's purview is around finances, right, and money and cost. So if there's an added step that would require unwed parents to also establish paternity, because isn't that something that has to be established before you can get to the issue of custody?
That's as it is.
Representative Scott.
I'm sorry, Madam Chair. That's as it is now.
Representative Champion.
And so with that being said, isn't it true that now there's this cost that is additional to the courts, because if you have unmarried folks with their kids coming in and there's this extra step of paternity, because you have to establish paternity, are these folks usually represented by counsel or unrepresented?
Representative Scott.
Madam Chair, I guess that varies. We have an individual that did a court case study, and it's kind of all over the place as far as who has a lawyer and who can afford one and who can't. A lot of people are going pro se now.
So,
Representative Champion.
Madam Chair, with that being said, is your understanding, based on your read of the studies and talking to the courts, that when there's an unrepresented party before the court, does it take more or less of the court's time in order to facilitate that process?
Representative Scott.
Thank you, Madam Chair. I guess that's something we've never had a discussion on with the courts, to be honest.
Madam Chair?
Representative Champion.
Because in my understanding, when you look at the cost to the court, that is an important question, because now you have an additional burden on the court, and based on the fiscal note, it says that that's one of the uncertainties, is because they know, number one, that when parties are unrepresented, that it takes more time to facilitate that case or the process, because they want to make sure that these unlearned folks understand the process, so that takes more staff time, that takes more of the judge's time, and so I just want to focus on whether you believe that there's going to be an additional cost, because that is the reality that the courts are faced with.
Representative Scott.
Thank you, Madam Chair. Representative Champion, no, I do not. I don't believe that at all.
Madam Chair.
Representative Champion.
Okay, so if you don't believe that, I'm reading here in the fiscal note where it says, under the current law, because the recognition of parentage does not give any custody or parenting time rights to the father, the custodial mother has sole legal and sole physical custody until a court orders otherwise. Thus, currently in such cases, an order is issued and the custodial mother receives a child support award under the guidelines as a sole physical custodian. It is unclear how a presumption of joint physical custody would apply in these cases. The Department of Human Services would have to set rules, and the courts would interpret how this would be applied. This lack of uncertainty would also apply to those cases where the parties do not sign a recognition of parentage and the county initiates a paternity action. Right? You also will see in the fiscal note that there will be an increase in cost based on post-judgment motions. And right now it says an increase, this is in the fiscal note, an increase in post-judgment motions could also result from confusion over the appropriate custody modification standards. Now, as we look at the standard that is being changed in your bill, it's my understanding there would be this rebuttable presumption only based on limited circumstances, such as if there's some abuse, or if you can prove that some parent has been negligent. Is that right?
Representative Scott.
Yes, we have the same standards as removing a child from a home in a CHIPS case, child in need of protection.
Madam Chair,
Champion.
And with that being said, the standard for a CHIPS case, which for those who don't know is children in need of protection and or services, is that the standard is clear and convincing evidence. Isn't that right?
Representative Scott.
Madam Chair, that's correct.
So the difference, though, in your case, in your proposed legislation and the CHIPS cases, in the CHIPS case, if the state is able to prove by clear and convincing evidence that a child is in need of protection and or services, there is a case plan that's put in place, and if that parent adheres to the case plan, that child is reunified or will always be reunified with their family, correct?
Representative Scott. And Representative Champion, we're kind of drifting here. So.
No, this is still getting to the financial issues. I'm trying to just at least lay it out so we can get to the financial question.
We're waiting.
Okay.
Okay, thank you, Your Honor. I almost called you Your Honor. Madam Chair.
Thank you.
Overruled.
Madam Chair, I think there was a question there.
Yeah, and I'm not sure that there was, so maybe if we can succinctly get
Okay, here it
to
is.
the point here.
So in
Some of us aren't attorneys.
So in this proposed bill, is it not true that no longer when we look at custody issues that we would not look at what's in the best interest of the child as it is right now under Minnesota Statute 518?
Representative Scott.
Thank you, Madam Chair. That's a question I can answer. The best interest standards are subject to the CHIP standards in this bill.
Representative Champion.
And would you not agree that when we think in terms of the route that is taken in order to get to this proposed legislation, if it was to become law, that the varied aspects of how you get there will add some burden or some unhidden costs that we don't really know about today? Would you agree with that or disagree with that?
Representative Scott.
Thank you, Madam Chair. Representative Champion, I don't think that we know. I don't think that we can say that. I don't think that the courts can say that because we don't know.
Representative Reinhardt.
Thank you, Madam Chair. I guess my line of thinking here sort of takes off from Representative Wagenius's issues around whether we really know whether legal costs will be reduced through this bill or whether they will be increased. And I know that's also where Representative Champion was going, but I need to just say a few things as background on the basis of Representative Scott's introductory remarks related to the gains to be made from shared parenting itself. I'm going to say that I have been discussing this issue since before I came to the legislature because I have a large number of fathers in my community who have been involved in moving this bill, and I probably spent hundreds of hours in conversation, in reading research, and listening to both parent advocacy groups and domestic abuse advocates and mediators and lawyers and judges. Every single person I've encountered in the last 6 years that had any connection to this issue, I've asked what they think about this issue. And after all of that, and I'm a strong advocate for shared parenting, and I think we need to figure out how it is as a society and a state we can promote shared parenting in the daily lives of our kids, whether it's in a divorce situation or any other situation. However, I've yet to be convinced that focusing on this statute and the legal presumption of shared parenting is the best way for us to get at advocating for shared parenting in children's lives. And the reason is that the majority of parents work out these issues in a divorce, work out these issues outside of the courts. 95% come to their own resolution. The 5% who don't obviously have some issues between them in terms of communication and conflict resolution, or they wouldn't be in that extreme situation. So I'm very concerned about moving the focus from the best interest of the child to the rights of the parent. That, to me, is the heart of the matter. And I know one can argue that the rights of the parent are in the best interest of the child, but I'm talking about legally, the exact legal definition of the best interest of the child. And when we move to the clear and convincing evidence rule, I think that we're losing judicial discretion. The judge no longer, you say parents come into this on an even footing. Well, that's the problem. And a great many of those cases in that 5%, parents aren't on an even footing. And this doesn't allow the judge to look at what is the real situation of these individual people in front of me. It requires the judge to accept that they're on an even footing, even though they might not be practically.
Senator Hamilton.
Thank you, Madam Chair, and thank you for bringing this bill forward. You know, I'm not an attorney, but I was raised by a single parent, a single mother. You know, I think about it, and I can remember the custody battles and stuff like that as well, and how my dad did want to be able to spend more time with his children. And, you know, even though my mom and dad were both good people, they hated each other, and they didn't talk much. And so I spent every other weekend with my dad and maybe a couple weeks in the summer. And I know, as a child, I would have liked to have been able to spend more with the father, right? And but unfortunately, it didn't happen. And so I appreciate the fact that you're bringing this forward and that the father can have some say in it. Because like I said, even though my mom is a wonderful, wonderful person, I love her dearly. I'm a mama's boy, you know. And but my dad was too, right? So, yeah, so I appreciate you bringing this forward. I guess my question to the author is the concern that I have in the event that a woman is a battered woman, right, and the children, what protections will they have to where the person that's doing the abuse is not able to make her life even more miserable by dragging her in the court and stuff like that? That would be my question.
Representative Scott.
Thank you, Madam Chair, and thank you, Representative Hamilton, for sharing that. Domestic abuse is still against the law. This bill does not change that. And all that we're asking in this bill is that what we're trying to get around, and I bet everyone around this table has gotten a letter from most likely a father who's been falsely accused of something, and that automatically disqualifies them in the custody battle. And so there are protections in here for domestic abuse, and the last thing we want to do is put anyone in harm's way. This bill.
Representative Carlson.
Madam Chair, I just wanted to go back to the amendment that was adopted that kicked the cost of this into the next biennium. And want to compliment you in requesting that we be informed with tracking the costs of the various bills that are going through the legislature. But just a reminder to the committee, as of April 5th, we're adding to the February forecast, which was a shortfall of $1.3 billion, over $200 million in future obligations, bringing us then to $1.5 if all of this were to become law. And each one of these increments is kicking more and more into the next biennium and creating a greater and greater deficit. And I just want to remind people that we are the last stop as a fiscal committee, and we have to keep these kinds of issues in mind. I would hope that the majority party would be fiscally responsible when we look at what these future obligations are, and I'm quite concerned. Now, the major one here is the tax bill. I understand that. But having said that, whether it's the tax bill or this bill or other bills that are coming forward, we're over $200 million in future obligations beyond the forecast.
Representative Champion.
Thank you, Madam Chair. I just want to clarify something based on the bill to Representative Hamilton. Representative Hamilton, as it pertains to domestic abuse, if you look at page 9, that there is this presumption that will be in place, right? And it would be on the other party to challenge the presumption by clear and convincing evidence. And so a person who's been the victim of domestic abuse, if you look specifically at line 9.16, they'd have to, there's that notion there. But here's where the kicker is in 9.17. And specifically, if you look at, well, starting at 9.17, a parent has petitioned for an order for protection and the petition has been dismissed or denied by the court, or a order for protection was filed by agreement of the parties without a finding of domestic abuse. So sometimes people can be petitioned and go to court, and the person would just say, without there being a court finding, I'll just agree to, the domestic abuse order because I don't want to go through the evidentiary process. So if such a person comes before the court, and that's been the order of the day as far as a no finding, now that person who's been the victim of domestic abuse has to now prove by clear and convincing evidence that they were abused by this particular person because there's no previous order that articulated the court's finding. So when you think in terms of a person who's been the victim of domestic abuse, there is an added burden, and they are going to have to try to now regurgitate that, bring that forward, or the court just flatly just deny it because there was no finding.
Madam Chair.
Representative Hamilton.
Oh, thank you. And what I just...
If I might, just real quickly, for members of the audience, this will be the last bill that we'll be able to do this morning. So if you're here for another bill, we'll have to come back after session to address those. Representative Hamilton.
Well, and just to follow up to that, what I'm concerned about is that we punish everybody because of bad actors. You know, even the good fathers. That's my concern. So how do we get to this, to where the good parents have an equal footing, but yet we can still get to the bad actors?
All right. Representative Kahn.
Yes, Madam Chairman and Representative Scott, I have a question about this bill that no one has ever answered, which is how is a decision made in the case of nursing mothers?
Representative Scott.
Thank you, Madam Chair. That is a question that we haven't gone over a lot, but I think in that case, most likely, the two parents are going to be what's going to happen here, folks, is the two parents going into a custody issue are going to have time to work this thing out on their own. And if they don't, then the judge steps in, okay? So first of all, our first hope would be that the parents are going to work that out. And maybe they defer. This bill doesn't say that you have to, out of the chute, both parents have 45.1% parenting time. They can work out any agreement that they'd like to. If 20/80 works better for them, they can do that. This bill allows flexibility. So our hope would be with the nursing mother that the dad's going to go, okay, I'm going to cut you a break here. Let's have you have primary time with the child right now. And again, the judge will make the final decision if those two can't come up with an agreement.
Well,
Representative Kahn.
Madam Chairman, this bill only really applies where people can't come up with an agreement. And it seems to me that's a particular, there obviously aren't many cases where we'd be looking at a newborn or early infancy child, but it's a perfect way for the father to be abusive to a mother, for example, who wants to nurse by insisting that they have it. And I obviously don't have an amendment prepared now, but would you object to an amendment that explicitly excluded the case of nursing mothers for the time of feeding, of nursing the child from any consideration of this?
Representative Scott.
Thank you, Madam Chair. Representative Kahn, I can talk with you offline about that.
Any additional questions or comments? Seeing none, I renew my motion that House File 322 as amended be recommended pass, refer to the General Register. All those in favor say aye. Aye. Opposed, nay.
No.
Motion prevails. Members, we are in recess to the call of the chair after session.